getting pretty impatient, but I know you.
Article 13, Clause 1 of Malaysian Federal Constitution. The article is about the property of a person that has been recognized under the law, such as land, houses, car, and so forth, should not be taken away or abused without any exception reasons, for example, bankruptcy.
So here I am going to talk about the Article 13, Clause 2 of the Malaysian Federal Constitution, which stipulates that only the right is recognized, that is the right to be adequately compensated under the acquisition of land. Whether it is adequate or not and what adequate really is, it is all the court to decide. And the reason for adequate compensation, if the property compulsory acquitted by government and it is not a compulsory for the reason of the acquisition to be a public purpose as the reason of the compensation itself. Also, the Constitution gives its citizen the right to property such as land, but it is also subjected that the government may take the land from the ownership of people and its citizen and merely gives adequate compensation in return under the Land Acquisition Act.
The case that are related to Article 13 of the Federal Constitution is the case Ketua Polis Negara against Kambing Huat. The fact of the case is, the plaintiff claimed that it is his right to get an adequate compensation after his own piece of land being seized by the Ketua Polis Negara, without giving any compensation after being charged under the drug law. The issue that arises in this case is, does the seizure of the property under the drug laws without giving any compensation is violating the Article 13 of the Federal Constitution. The court held in this case is, as stated in the Dangerous Drug 1988, the government can seize property without paying the land owner is when the police believe that the property is used for the criminal purposes. In order to seize property, the police typically must prove the court by the preponderance of the evidence that the property is substantially likely to be connected with the criminal activity. Preponderance of the evidence is much more difficult standard to be met than the probable cause standard required for an arrest. It means that the police must convince a judge that it's more likely than not that the property connected to a crime. If the police simplify had met the probable cause standard, they would have shown that the prudent person could believe that the property was connected to the crime.
Hello, I'm going to explain briefly about a case regarding Article 13. This case is about Nor Anak Nyawai and others against Borneo Plantation Sendirian Berhad. It was claimed by the defendant that the second defendant, Timber Company, had trespassed and there was damage done to the ancestral land. Also, the plaintiffs have acquired native customary right over a certain part of the land, which is the disputed area. The issues that the court had decided were, first, whether a representative actions were suitable in this case. Secondly, whether the plaintiffs and their ancestors had exercised those rights continuously in the disputed area. And also the issue whether they are to an extent of their rights to be effected until being extinguished by any law, legislation or rules throughout the period. And lastly, the issue in this case call for the resources to which he has no documentary title and an examination to the rights of an IBAN relation to the land.
Held. It was assumed that the court could not award damages, since the court could still grant the declarations if the plaintiffs had established the case. It was also claimed by the plaintiffs involving declarations which made the action a suitable representative action. If the plaintiffs failed, it doesn't matter whether this is a proper action, since the action is going to be dismissed anyway. In the disputed area, native customary rights have to be exercised by the plaintiffs and their ancestors. It will be enough proofs if the customary rights that have been practiced 200 years ago is being practiced by the present generation that have been described by historians as having been practiced 200 years ago. To that effect, there must be clear ambiguous word if it was intended that the existence of customary rights is since 242, a law journal in 2001, before the time of first Raja, and that had survived through all the orders and legislation were to be extinguished. However, the court simply left this issue unsolved and did not provide any further elaboration regarding the extent of rights and the nature encompassed by native customary rights.
In a nutshell, Article 13 of Malaysian Federal Constitution does not only provide the physical thing about itself but also the surrounding rights such as exclusive use, the right to bequeath, also to alienate by sale, gift or exchange. This also provides that no one shall be deprived of property in accordance to law. In short, there is no law that provides for the use of property without adequate compensation or compulsory acquisition. Nobody can deny and oppose the idea of human rights as they were enriched in the Constitution itself.
This is a shout out to my ex. Heard he in love with some other chick. Yeah, that hurt me, I'll admit. Forget that, but I'm over it. I hope she getting better sex. Hope she ain't picking it like I did.